Of that opinion will say aye. Contrary will say no. The ayes have it. The question now is that Part 2, debate on clauses 16 and 17, stand part.
And Mr. Chairman,
The Honourable Christopher Finlinson.
I just want to address a couple of matters raised, and I know that Dr. Kennedy Graham wants to say something about it, in relation to clauses 16A and 16B set out in the SOP. And the background to it is this. These clauses are going to set out the determination of the additional remuneration of High Court judges when serving in the Court of Appeal, because High Court judges can either join the permanent judges of the Court of Appeal in the full court of the Court of Appeal, or they can sit with Court of Appeal judges in either the civil or criminal divisions of that court. Apparently, there was always a broad agreement about the remuneration that High Court judges would receive when they were sitting as judges of the Court of Appeal, and it results from an arrangement which was entered into by the then Chief Justice and the then Secretary of Justice, and it was resolved that High Court judges should receive the same salary as Court of Appeal judges as determined by the Remuneration Authority for their service in the Court of Appeal. And so it might be for 2 or 3 weeks, it might even be for a couple of months, but that was the arrangement that was reached. Some years ago there was a case which came before Justice Mackenzie in the High Court at Wellington called Wickigo and Beckham and the Attorney General, and I refer the member to the judgment dated 11 July. It was a broad-ranging attack on behalf of those applicants on the way in which certain judges were sitting on particular cases, be they as retired judges with a temporary warrant or judges of the High Court sitting in the Court of Appeal. And so questions were raised, and Justice Mackenzie looked at this issue, and while he didn't express a final view on the issue, said, and I quote, that given the importance, the constitutional importance of judicial salaries, I consider the payment of an allowance to a High Court judge sitting on the Court of Appeal should rest on a more secure constitutional foundation than is apparent on the evidence before me, end of quote. So he did not express a final view, but he made that comment, and so it has been thought that the sooner this matter can be cleared up, the better. The judgment was given on 11 July 2008, and this was simply seen as a good time, given the relative infrequency of legislation affecting the Judicial Act coming before the House, that we should take the opportunity and try and sort it out. Now, the question that I believe the member may raise is the question of retrospectivity, and admittedly 16B adopts a belt and braces approach. I'd suggest to the honourable member it's not like cases of retrospectivity which validate, for example, an unlawful taking, but it's a declaration in a belt and braces way, and it's simply dealt with in this way because the issue was raised but not finally determined before that learned High Court judge.
Call Charles Cheval.